My dear friends, good morning. Today's topic is the principle of strict liability and absolute liability. It comes under the top. My name is K. Umeshro. I am requesting you to subscribe to my channel as it gives motivation for me to give more and more topics. Now we are discussing what is strict liability and what is absolute liability. Strict liability law says you enjoy your property in such a manner as not to injure that of another person. But there are certain actions, there are certain chances of causing harm to injury to others. In order to remove harm or injury, solution is found by the judiciary, that is no fault liability, strict liability. The principle is evolved in Rylands versus Fletcher case. Under strict liability, person is liable for the harm caused to others, even if he has no intention, even if there is no negligence towards others. It is no fault liability. In negligence, harm can be avoided by taking precaution. But in strict liability, harm threatened is the extraordinary risk and exposed towards others. Rule says the person brings in his land anything to do mischief. If it escapes, he must keep it as it is peril. He is answerable to all the damages. Essentials of strict liability: dangerous things brought on his land by the person. Dangerous things escaped outside the area. Dangerous things stored or brought in his land for non-natural use. Three important points here. First, he has stored some dangerous things. Second, these dangerous things escaped from his premises. And he has stored this dangerous thing for non-natural use. In this connection, strict liability, we will study one case law, Ryland versus Fletcher. A person is liable for the harm caused to the other, even though he has no intention or negligence towards others. This is called strict liability. What is the principle involved in the strict liability? The liability arises not because there was any fault or negligence on the part of the person. Liability arises because he kept some dangerous thing on his land and it has escaped. Dangerous thing has escaped from his land and it caused damage to the neighborer. In such cases, liability arises even without any negligence on the part of the defendant. Case law: Fletcher has a mill. To supply water to his mill, he employed the contractor to construct the reservoir. It is for storage of water. The purpose of reservoir was to provide water to the defendant's mill. There are old disused shafts under the site of the reservoir. This fact was known to the defendant or contractor. They did not take any precautionary steps to avoid any such damage from such disused shafts. While constructing, the employees were not properly filled with these shafts and passages. Shortly after construction, the water overflowed from the reservoir through disused shafts and passages and entered into the coal mine, and it affected and stopped the work. Ryland was the owner of the coal mine. Ryland sued for damages, and Fletcher proved that there was no negligence on his part. He argued He did not know the presence of the disused shafts. He took all precautionary steps as a prudent man can do to prevent any damage. He pleaded. Construction was handed over to the independent contractor and he was not aware of it. He is not liable. He contended that flood from the reservoir was an act of the God and it cannot be foreseen by an ordinary person. But the House of Lords gave the judgment unanimously held that the defendant is liable for the compensation. The rule laid down in this case is that person who brings on his land and collects and keeps there anything to do mischief, if it escapes, it must keep it in his at his peril, and if he doesn't do that, he prima facie answerable for all the damages, which is the natural consequence of its escape. The rule also extends to explosive materials, poisonous gas, machinery, dangerous items, dangerous articles, dangerous animals. There are situations when a person may be liable for some harm even though he is not negligent in causing the same positive efforts to avoid the same. This law recognizes no fault liability. What is the essentials of strict liability? Dangerous things brought in his land. A thing collected is of dangerous thing, and it escapes her, and it likely cause injury. The person who collects it is liable. Example, it may be electricity, gas, poisonous gas, sewage, explosives, noxious fumes, and rusty wire, anything. Escape, if the thing escapes outside the area, out of the control of the defendant. For example, if there is a projection of branches of a poisonous tree on the neighbor's land and it escapes, and if the cattle lawfully there on the neighbor's land eats the poisonous leaves of the tree, then defendant is liable. In another example, if the plaintiff's horse intrudes over the boundary and dies by eating the small piece of leaves of poisonous tree, then defendant is not liable. Third one, it is for the non-natural use. It is for the special use. It was brought and it escapes from the premises and causes damage to others. What is the meaning of non-natural use? In the case of Ryland versus Fletcher, water collected in the reservoir is such a huge quantity, it is held to be non-natural use. Keeping water for ordinary domestic purpose, it is for natural use. Strict liability, there are some exceptions. What are the exceptions? Act of the God. It is a direct, violent, sudden, and irresistible act of nature which cannot be foreseen or resisted by a human care and skill. Example, storm, tempest, lightning, extraordinary fall of rain. It cannot be anticipated. Second, it is the act of the third party. The harm caused is due to the act of the stranger who is neither defendant servant nor the defendant. They don't have any control over him. The defendant is not liable. Example, a person located on the second floor of the building and he is a lessee of the defendant. There are continuous overflows of water from lavatory basin on the top of the floor due to the open of the tap by a third person. The defendant is not liable unless he instigated that. Plaintiff's own act. The rule of strict liability does not apply where the escape is due to the plaintiff's default. Example, plaintiff is a trespasser who knowingly brought the risk upon himself or for natural use of his property. Even the escape could cause any damage. Defendant is not liable. Plaintiff and defendant occupied the adjoining farm which they rented from the same landlord. Both plaintiff and defendant entered the agreement with the landlord regarding keeping the fence in a good repair. Later, the divided farms became out of the repair, and two horses of the defendants escaped from his field and occupied the field of plaintiff and thereby causing injury to the plaintiff's young horse. Here the plaintiff had committed a breach of obligation to repair the fence. Consent to the plaintiff. The rule does not apply where the escape due to the artificial work is maintained with plaintiff's consent for the common benefit of the defendant. Example: plaintiff and the defendant occupied the two parts of the same building. Water is laid on the building which escapes and causing damage. The person from whose part escapes, he cannot be liable. Statutory authority. Persons authorized by statute to bring to keep upon their land a dangerous substance are not liable on the rule of Rylance versus Fletcher. Defendant company had a statutory authority to supply water to the town by pipes. Water pipe broken without the fault of the company. Water entered up into plaintiff's house and caused damages to the goods. Held, defendants were not liable. Another is absolute liability. What is absolute liability? The wrong arises from the breach of absolute liability. It is more harsher than strict liability. What is absolute liability? In tort, the criminal law, to convict a person must not only have committed a criminal action, but also had a deliberate intention or guilty mind or mens rea. In the crime of absolute liability and strict liability, a person could be guilty even if there was no intention to commit crime. Strict liability and absolute liability arises from dangerous activities or defective products that are likely to result in harm to another regardless of protection taken. Negligence is not required to be proved. The duty which renders a man liable without any fault of his, irrespective of any consideration of intention or negligence on his part, is very important. That is not necessary for the injured party to prove any intention or negligence on the part of the injuring party, and no amount of care and caution expended by the latter to prevent the damage done to the former will excuse him. Now, what is the difference between strict liability and absolute liability? Absolute liability is stronger than the rule of strict liability. In the rule of strict liability, there are exceptions like act of the God, act of the third party, plaintiff's own mistakes, consent to the plaintiff, statutory authority. But in the rule of absolute liability, there was no such exceptions. Defendant has no chance to escape as in the case of strict liability. The court said the owners who produce dangerous and hazardous nature of products do their activities for their private profits. There is a social obligation upon them to compensate those people who suffer from their activities. The court said owners are responsible persons to guard and check the mishappening because they have resources and knowledge. In some cases, Supreme Court ordered to close and relocate the industries causing pollution by adopting the principle like polluter pay principle, precautionary principle, and sustainable development. Now we will go for case laws. MC Mehta versus Union of India, oleum gas leakage case. 4th December 1985, oleum gas was leaked from one of the units of Shriram Foods and Fertilizer Industries. It resulted in the death of one advocate and injured several persons. One Mr. M.C. Mehta filed case before the Supreme Court. The defendant pleaded that the defenses available under the rule of strict liability. Supreme Court laid down a new rule of non-delegable duty to community and obligation to provide that the hazardous activities must be conducted with the highest standard of safety. The Supreme Court gave the judgment in favor of the victims and the defendants are held liable to pay compensation. Another case is the Bhopal gas leak case. Union Carbide Corporation versus Union of India. On the night of the 3rd December 1984, dangerous gas was leaked from a pesticides plant situated at Bhopal. Plant belonged to the Union Carbide Corporation. As a result of the leakage of gas, about 3,000 persons died and 6 lakh persons suffered permanent disability. The Government of India sued the Union Carbide Corporation in the Supreme Court of India. The Supreme Court gave the judgment ordering the defendant to pay 750 crores to the victims and the dependents of the deceased. Thank you.